Be ready. 5 seconds. Start. These two petitions have been filed under Article 32 of the Constitution of India for seeking directions to the respondents, that is, the High Court of Delhi and Government of NCT of Delhi, to offer appointment to the petitioners on the posts in the cadre of District Judge. Stop. The facts and circumstances giving rise to these petitions are that in order to fill up 20 vacancies in the cadre of District Judge in Delhi, the respondent number 1 and the High Court of Delhi issued an advertisement on 19 May 2007. Stop. Out of these 20 vacancies, 13 were to be filled up from the general category candidates, 3 from scheduled castes candidates, and 4 from scheduled tribes candidates. Stop. The petitioners who belong to scheduled castes category faced the selection process. Stop. The result was declared on 3rd January 2008. Stop. All the 3 vacancies reserved for scheduled caste candidates could not be filled up as the respondent number 1 found only one person suitable for the post. Stop. The 2 petitioners herein were found unsuitable on the ground that they did not secure the required minimum marks in interview. Stop. Hence, these petitions. Stop. Shri Shekhar, Learned Senior Counsel, appearing for the petitioners, has submitted that in view of decision taken by the respondent number 1, a candidate belonging to scheduled caste category would be called for interview provided he secured 45% marks in written test. Stop. Only 3 candidates belonging to the said category stood qualified in the written test. Thus, they could have been offered the appointment without asking them to complete the formality of facing the interview. Stop. It was not permissible for the respondent number 1 to fix minimum benchmarks at the interview level also for the purpose of selection. Stop. The petitions deserve to be allowed and the respondents be directed to offer the appointment to the petitioners. Para. Per contra, Learned Senior Counsel, appearing for the respondents, has vehemently opposed the petitions, contending that mere passing the written test is not sufficient for appointment, as some of the required qualities of a candidate can be assessed only in viva voce oblique oral examination. Stop. The competent authority is permitted in law to fix the minimum marks at interview level also. Stop. In case the candidate does not secure the marks so fixed, the candidate cannot claim the appointment to the post. Stop. Decision for fixing the cut-off marks in the written test and further for securing the minimum benchmarks in the interview had been taken prior to initiation of selection process and was made public at the same time. Stop. The petitioners did not challenge the said criteria at the appropriate stage. Stop. Once they had appeared in the examination and could not succeed, petitioners cannot be permitted to take U-turn and challenge the selection process on this ground at all. Stop. The petitioners lack merit and are liable to be dismissed. Stop. We have considered the rival submissions made by the learned counsel for the parties and perused the record. Stop. The advertisement dated 19 May 2007 provided that selection process would be in two stages, as it would comprise of written examination carrying 750 marks and viva voce carrying 250 marks. Stop.